Hi, welcome to the DC Bar Pro Bono Center's on-demand video, Options to Resolve Your Family Law Case. Please note this video gives legal information and not legal advice. The DC Bar Pro Bono Center does not represent you, and the DC Bar Pro Bono Center is not your lawyer. Throughout this video, we will give you helpful resources to resolve your case in family court. Before we get started, I want to draw your attention to a new resource in the district. Virtual DC Court was created with the DC Bar Pro Bono Center, Utopian, and the District of Columbia Courts. You can access the virtual DC Court at the link on the screen or by scanning the QR code. Through this resource, you will be able to see what it's like to be in DC Superior Court, to go through security, to see where different courtrooms are and court offices and resources are located. You can click on the resources to determine their hours, types of services, and location. Additionally, if you've never been to a court hearing and you may be nervous, you can see what it's like to be in a courtroom with a judge and all the players. You'll be able to see where the judge sits, who the clerk is, what they do, and understand what it's like before you go to your custody hearing. So let's dive in. What are the options? There are actually many options to take advantage of at any stage of a family law case, or even before a case is started. For example, there is the court's free mediation program called multi-door mediation. There are the free attorney negotiators at the court. There is alternative dispute resolution, or ADR. There's also judicial mediation, and of course negotiating with the other side. We will dive into each of these separately. If you are able to reach an agreement, you can inform the court and push for a sooner hearing to enter the agreement. For uncontested divorces specifically, when you are filing for divorce, if you are able to reach an agreement on the issues, or if there are no issues that the court needs to resolve, you can file a request for an uncontested divorce hearing so that the case can be heard quicker. Let's start with option number 1, an integral component of the DC family court system, the Multi-Door Dispute Resolution Division, or in shorthand, multi-door. Multi-door covers a range of matters. Specifically for family law, it covers divorce, legal separation, alimony, dividing marital property and debt, custody, visitation, and child support. This is a free service if you live in DC or there is a DC case. And this is an amazing service because it can happen anytime throughout the life of your case, but you can also open a case with multi-door dispute resolution before even having a case in the court. You can also use multi-door dispute resolution after your case is closed to resolve issues that come up post-adjudication. That means anytime after a case is closed, if somebody's not following an order, or maybe you want to change it or talk about interpreting it, you can go to multi-door mediation to try to work it out before filing something with the court again. Multi-door mediation can be court-ordered or it can be voluntary. The process begins with an intake stage. That can happen in person or by phone. Once you complete your disclosures and give the information needed to the intake staff, you will be able to schedule and attend mediation sessions. This usually happens 2 to 3 weeks after the intake of both parties. The mediators will make sure that the parties have time to meet on a specific day and time. Are they going to meet in person or remote? And what type of mediation is it going to be? Is everyone going to be in the room? Is it going to be shuttle, in which the mediator might go to separate rooms, either virtually in person, between the parties? The parties must agree if they want to allow their legal representatives and or guardian ad litem to attend. And again, it is voluntary, but the judge may consider your willingness to co-parent when making custody decisions if you have not attended mediation or refused to participate. In mediation, they will ask for your financial forms, for assets and liabilities, income, children expenses, etc., if those issues are at hand. The mediator's office will also update the court docket to reflect if either party has attended, if they've terminated mediation, or if they've refused to participate. If a temporary or permanent agreement is reached, or there needs to be additional mediation, or there needs to be additional court hearings before mediation continues, the multi-door mediation office will alert the court of those needs. The link on the screen at the bottom takes you to the court's website so you can learn more about all the services that multi-door dispute resolution offers. Multi-door mediation is located at 410A East Street Northwest in Washington, D.C. in Court Building C. This is what the building looks like, and the map on the left shows you its location. It is right across from the Judiciary Square exit of the Metro. The phone number on the screen, both for the general number and the family law intake, are readily available, and if you don't get an answer, please leave a message and they will call you back. If you need to email them, their email is also on the screen, mediationintake@dcsc.gov. Another option to resolve your family law case is the Family Court's Attorney Negotiator Program. The role of the attorney negotiator is to assist the parties to reach a resolution in the matters before the family court. The attorney negotiators provide legal and procedural information to the parties, such as explaining the law, the impact of the law, the statuses pertaining to the domestic relations case, and perhaps the process of filing pleadings or the posture of the case. The attorney negotiators, while they are attorneys, they do not act like an attorney to the parties. They are neutral, so they don't provide legal advice and they don't represent any of the parties. The attorney negotiators use alternative dispute resolution methods and techniques to help parties reach a temporary or permanent agreement. Again, they do not provide legal advice. They help identify issues, reach solutions, and draft agreements. They are really a liaison between the litigants or the parties and the judicial officers or judges. So they will update the court with how the attorney negotiator session went and if there's been an agreement or not. If there has been an agreement, they will often draft it up, have the parties sign it, and send it over to the judge. It is important to note that this is not confidential. So how does a party reach the attorney negotiators? There are really two ways. One is that you are at a hearing, either your initial first hearing or perhaps a status hearing, and the judge passes your case so that the parties can go to the attorney negotiators. This means that the judge will let the parties leave the courtroom so they can speak to the attorney negotiators and then call the case later on in the day. During the time with the attorney negotiators, the parties will again try to negotiate a temporary or permanent agreement. They will attend that mediation, most likely in person the day of the hearing, but sometimes remote if the hearing is remote. And if successful, the attorney negotiator will draft up the temporary or permanent agreement and send it back to the judge. The parties will then call their case again and enter the agreement. If it's unsuccessful, that is fine. The parties will likely go back to the hearing, and then the court will schedule either further mediation opportunities or set the case on a path to trial. The second option is that the court may issue an order for the parties to go to the attorney negotiators another day. So therefore, the attorney negotiator will contact the parties via email or phone, or perhaps the parties will contact the attorney negotiator depending on the court instructions. And then the same process will follow. The parties will attend the mediation with the attorney negotiators, either in person or remote. And if successful, the attorney negotiator will send the agreement to the parties and to the judge. And if unsuccessful, the parties will continue on their path towards resolution, either other methods of resolving the case or to trial. You will often hear throughout the life of your case that the parties, the parents, know their lives better than the judge, and therefore the parties can create something that will work best for them and their family. The litigation process and going to trial can also be financially, emotionally, mentally, and physically draining. And it can take a long time. If you are able to reach an agreement, you can ask the court to enter that agreement, and that's through any of these methods. Another method is to negotiate directly with the opposing party, the other side, and or if they have a lawyer, their lawyer. This is only if you feel comfortable doing so. So you can communicate with the other side. You can work together to draft the agreement and or a proposed order that you want the judge to issue. Once you finalize the agreement, the parties should both sign it and send a copy to the judge. And then you can ask the court to have a hearing sooner to enter that agreement, or ask the court just to simply enter that agreement. Another option is alternative dispute resolution, or ADR. There's a court-approved list of mediators who are family law attorneys who offer a discounted rate when there's a referral from the court of $200 per hour. These skilled family law attorneys act as a neutral mediator between the parties to hear their issues and help them resolve a resolution. Who pays for it? That is really negotiated upon the parties with the court. So maybe the parties split it, or maybe one party pays for it, or there's some percentage breakdown. If the parties both can't afford it or it's cost prohibitive, the parties are able to ask for it to be done pro bono or for free, and that is sometimes an option but not guaranteed. Another option is judicial mediation. This is an option where a judge, not the judge hearing your case, but another sitting judge unrelated to the case, helps the parties reach a resolution. This is a free and helpful resource because it can give parties a more realistic sense of what might happen if they were to go to trial. Judges, because of their positions, may be more persuasive or effective at helping parties really understand what the issues are, the likelihood of the outcomes, and reach agreements. You can ask the court to order judicial mediation in your case. If you are representing yourself and do not have a lawyer, you can access the court forms at the DC Bar Pro Bono Center's Family Law Pleadings page or at DC Superior Court's Family Court Operations page. The links are on the screen. If you need help completing the forms or getting more legal information, you can go to the Family Court Self-Help Center at DC Superior Court in room JM 570. The Family Court Self-Help Center is open Monday through Friday from 8:30 to 5 p.m. The last intake is at 4:30 p.m. Additionally, if you need more information about how to file for divorce in DC, how to understand the DC child support calculator, how to file for custody, what to do with different evidence at hearings, how to issue or respond to discovery, you can scan the QR code on the screen for a series of self-represented videos to help you in family court. Thank you.